Sorry, I was deeply engrossed in this story, which is part of today's historical moment. My name is Tony Geoffrey Owana, who welcomes you to Owanapaedia, your one-stop center for the history of Uganda. In charge of operations is Herbert Semiano, my second in command, and also the other ranks of this three-man unit. The third person, you will know him one day. The subject we have today is a legal one, and it centers on an issue which has been troubling you and many others, and it is the subject of the president's position on bail. There's a fear that President Yoweri Museveni has a war on bail, and believe you me, if he really has this war, you and me should get worried. However, there are those who are saying that Museveni has a bail problem because he cannot manage to successfully prosecute the suspects he gets to arrest, and therefore just wants to imprison them. That is something to look at. And some of you have been speculating that his latest demand for a revisit of bail rights is based on the arrest of two members of parliament, the Honorable Alan Sewanyana and the Honorable Seizure Muhammad, once upon a time Edoboziri Echebanda, until he became for the whole constituency. It's a while now they have been in prison, and their hearing is yet to start. That's a long time. And indeed it is true, justice delayed is justice denied. But to accuse Museveni of trying to change bail because of Sewanyana and Segirinya is unfair.
Tony Owana really loves our history. He has a passion for doing research, and he shares all this history with you so that you can make informed choices.
Banange, have you subscribed to Owanapaedia? I don't know what you are waiting for. The president first made his position on bail clear in 1987 when he met members of the Uganda Law Society on the 25th of February at their own invitation. At that time, from my calculations, Honorable Alan Sewanyana was 90 days old, and Segirinya was expected a year later. So they cannot be the basis of Museveni's complaint about what he calls automatic bail. So what was I reading in this newspaper? The Star newspaper of Wednesday, 25th February 1987, carried a big story titled Mwanga Kaira Lwanga freed on treason. It was reported by John Kakande, Crespo Sebunya, and Katende. Now, the gist of this story, ladies and gentlemen, was that court had found that the state did not have sufficient evidence to charge Dr. Andrew Takome Kaira and about 7 others of treason charges, and they were therefore freed. When the president met the Uganda Law Society, his position was that my soldiers are failing to understand how you lawyers work. They catch people with guns, and you people discover that even though they had the guns, there is no sufficient evidence to confirm that they did have the guns. So the president was expressing his unhappiness. Fortunately, he did it in a meeting of the Uganda Law Society, which is the subject of today's historical moment at Owanapaedia.
Tony Owana really loves our history.
Banange, have you subscribed to Owanapaedia? I don't know what you are waiting for.
History with you so that you can make informed choices.
Bail is another area of our criminal law which must be re-examined. I've been having a lot of difficulties with our soldiers. They cannot understand bail. They really don't understand, and even yesterday I was explaining to them. Somebody was found with a gun and he's bailed. that some law says that illegal possession of a gun is a bailable offense. Really, this is discrediting the legal profession in the eyes of the National Resistance Army. This I can tell you a secret.
Really loves our history. He has a passion for doing research, and he shares all this history with you so that you can make informed choices.
At that time, the Uganda Law Society was led by the late Henry Kayondo. When he rose to speak at the opening of the event at the International Conference Center, he told the president that for the first time in the history of the law fraternity, he was happy that there were many lawyers who were in politics as members of parliament in the National Resistance Council. Two, that there were many lawyers who had participated in the struggle in the bush, both with guns and with other means. And three, that the fraternity in which they were gathered was the largest in the history of that gathering. That was Henry Kayondo. Henry Kayondo himself is a very historical figure. It is him who, I'm convinced, had caused the National Resistance Movement to issue its legal notice number 1 of 1986 to declare that it is the one in power. Why? Because it was assumed that upon taking oath on the 29th of January 1986, President Museveni's oath was what it required to put a government in place. That was overlooked. Until Henry Kayondo, who had been appointed by the previous regime of General Tito Okello as an ambassador and was not deployed, raised a legal issue with the government saying, you deployed me, but you have not facilitated me to go to my next station. But when Kayondo checked the books, he discovered that the government legally in power was the one of General Tito Okello. That's how he alerted the government, and they issued legal notice number 1 of 86 several weeks after taking power. So Kayondo was a historical figure. Kayondo had been a police officer before he went into private practice. And indeed, another peculiarity with Kayondo is that he one time came out to defend the Public Order and Security Act 1967, which permitted the government to detain suspects without trial for periods of 6 months, renewable. Kayondo had joined the Democratic Party in 1980, and when he expressed this opinion, people who were in the DP said, look at this man. But as a lawyer, and you better pay attention to what Kayondo's position was, he said, governments have capacity to make people disappear. But if there's a way in which government can accept responsibility for the detention or holding of someone without due process, like taking him to court, it's better than that person simply disappearing. That was Kayondo. I am one of those who really hated him for that position. But over the years, I've come to realize that a government can deny knowing where Herbert Semiano is when a government agency has Herbert Semiano. Why? Because they are having him illegally, so they rather deny than accept in an instrument that they are keeping him in detention without trial. That is a subject for another time, but think about it. So when Kayondo was opening, he invited the Minister of Justice, was also the Attorney General, and that is the late Justice Emmanuel Nyamihana Mulenga. Mulenga had been a candidate of the Democratic Party in the 1980 elections in Kisoro, and I think he was defeated by UPC's Philemon Mateke. I'm not very sure, I'll check. But he became vice chairman of the Democratic Party. And he himself said that he had never seen such a gathering of lawyers, and that in the course of his life in the law, most lawyers had, in the regimes of President Amin and President Okello, been preoccupied with hiding from the state than pursuing the law. That was Mulenga. And after giving his brief, he invited President Yoweri Museveni to speak. Owanapaedia is proud to exhume this historic document for you, because the debate on the rights of bail is still very, very much alive in the minds of those concerned. Over now to Conference Center, 25th February 1987.
Your Excellency, President of Uganda, my Lord Chief Justice, Honorable Ministers, my Lords, ladies and gentlemen, permit me to make one observation before I invite you, and that is that the gathering you see today is, in my experience, unprecedented. I was chairman of the Law Society for some years, but I had never witnessed a gathering of this size and of such a variety of members of the legal profession as we have today. But that's because I should mention that my period was a time when lawyers spent more time struggling or fighting against oppression and hiding away from the forces of oppression. Mr. President, you have been described as a champion of the freedom for this country. You are yet demonstrating, and I think the turn-up today confirms that you are also championing the rule of law.
You invited me to address you on a topic of my choice. And the topic I intend to talk about is law reform in Uganda from the NRM point of view. Depending on the nature of the state in a given society, law can be an instrument of oppression and exploitation, or of social justice and progress. Law is not synonymous with justice. It's not always synonymous with justice. It can be, but it may not be. What is legal is not necessarily what is just. Law can be used by the strong against the weak, by the rich against the poor, by the minority against the majority. Historically, law has been used by the oppressor against the oppressed. During the slave period, slaves were owned and disposed of like chattels, and it was perfectly legal to own a slave. In those days, you could legally own a slave, and your rights as a slave owner were enforceable in courts of law. The slave had no legal right to property, to human relations, such as to have a wife and children, and even to life itself. The life of a slave could be taken away by the slave master at will. And it was the legal right of the slave owner to kill his slave. In the United States, it was forbidden by law for a slave to have education. During the feudal period, a feudal lord was legally entitled to the free labor and money of his serfs or vassals whom he permitted to live on his land. During the colonial period, law was used in some colonies to deprive Africans of their land and settle them in reserves. In South Africa, as you know, law is still being used to suppress the blacks and to deny them their political, social, and economic rights. The NRM government is strongly opposed to having laws on our statute books which serve the interests of the minority as against the majority of our people, or which in any way serve to promote injustice or advance backward interests in our society. The place the governments of Obote and Amin accorded law in their order of priorities was, as you all know, very low indeed. They had no respect for the rule of law, and their record of gross violation of human rights through murders, detentions without trial, tortures, disappearances, rapes, and robberies is not going to be easily surpassed anywhere in the world. Such governments could hardly have been expected to make any positive changes in the legal setup we inherited, and consequently our law remains 24 years after our independence, largely laws left behind by the colonial government. Obote did not have time to modernize the law. So right now, Obote and his protege, Idi Amin, they had no time to modernize the law. So as of now, some of us are seeing discrepancies between reality, between the desire to have justice and the existing law. We see there's a very big discrepancy, especially we who have just come on the scene from where we were. Because where we were in the bush, we really were serious with human rights. You could not play around. Our law was stronger on the side of the people. But here, we find a very big gap between justice for the population and the law, the state law as it is on the statute books. Their values were not our values, the values of the colonialists. You see, one of the things, if you want to understand philosophy, is to, for instance, as far as politics is concerned, is to define the state. You see, because law is an instrument of the state. But before you talk about the law itself, you must talk about the state itself. This state, what sort of state is it? For instance, the South African state is a racist state. It has declared its character. It says we are racists. We don't believe that human beings are equal. We believe that some races are superior and others are inferior. That's the character of that state. They have defined the character of their state. And having defined the character of their state, they have gone on to evolve laws which defend the world outlook of that state. So if a South African sees a black man and a black woman, he thinks it's a disaster, and that the world is going to go up is going to blow up. Of course, if they confine themselves to not allowing black men and women to consort, I wouldn't worry about that. After all, I'm not very anxious for it either. But they don't confine themselves there. This is really just a camouflage. They go further and ensure that 70% of the land is owned by 10% of the population. And that's the real core of racism in South Africa. Hence, even on that account alone, we should soon after independence have embarked on a careful examination of all our laws with a view to working out a legal system that was meaningful and suitable to the values and circumstances of our people. Just as there was no effort to disentangle our economy from a state of total dependence to a reasonable degree of independence, there was similarly no effort made to work out a legal system that took into account our local peculiarities and the level of our socio-economic development. Even when laws spring from society without being imposed by an outside power, they have to be reformed to suit the ever-changing social, economic, and political conditions of society. The crimes that are being committed today, for example, could hardly have been imagined at the time when we got independence. We have a situation whereby state security organs are used to decimate whole populations. Some businessmen are given millions of dollars of our scarce foreign exchange to import essential goods for the country, but choose to keep the money abroad and bring nothing home. We have embezzlers stealing public funds at a scale unheard of before. We have smugglers. We have robbers who use guns, which were passed to them by the past criminal regimes, to steal people's vehicles and other property. You see, for instance, on this issue of the past governments giving guns to wrong elements, I can cite the example of Okero, Tito, and Basilio, especially Basilio. Tito was not so active, but especially Basilio. You know, when we were fighting him, and we were in Mitiana area and here in these areas, Katonga and so on, he went to Karamoja and contacted the cattle raiders. He said, if you agree to fight for me, for him, for Basilio, and I give you guns, I will allow you to repay yourselves by capturing all the cattle in the western side of Uganda and taking them back to Karamoja. Imagine a leader of a country bringing known cattle thieves, arming them, and saying that you go and you will reward yourself by the loot you get. You see? And he gave them quite a huge chunk of guns, and these are the guns we have been recovering from the cattle raiders in Karamoja ever since. So far, we have recovered something like 3,000 rifles from the Karamojong cattle raiders, and yet there are still others at large. Now, this sort of situation needs an appropriate law. You cannot just use these ordinary laws to deal with this type of situation after you have inherited the state from such primitive elements. Imagine if I was to call the condos in Kampala and say, condos, please, ally with me so that I fight the rebels in the north. Then at the end of the day, you keep your guns and you repay yourself with those guns. And I am being described as a national leader, even for 5 minutes. That's a real disaster for Uganda, to have that type of leadership, even for 5 minutes, because in 5 minutes you can do a lot of damage. You can sign dangerous decrees and so on. Now, having had such leaders for not 5 minutes or 1 hour or 1 day, but for 24 years, is a real disaster for Uganda, and we need special efforts, not least in the legal section. We have people who deliberately undermine the unity of the country by openly promoting tribalism and advancing other sectarian tendencies. In some cases, you find there are no laws to cover such cases, and where such laws exist, sentences do not have enough deterrent effect. For instance, tribalism and sectarianism. In the past 20 or so years, it has been regarded as politics. If you can manipulate the tribes, you can manipulate the religions, then you are a fine politician. You are a clever politician. That's what Obote used to do. He used to call himself a master politician because he was a master intriguer. Because he was a master of intrigue, therefore he was a sublime politician. Now, that's why Uganda has got where it has got, you see. The law must therefore be reformed to accommodate such changed conditions in our society. On the side of criminal law, our laws must be made potent to deal effectively with crime. It must be made abundantly clear to everybody that crime does not pay. You know, when I grew up in Ankole, in the Nyankole language, they used to say, if somebody annoyed you, you would say in the Nyankole language that eshikijungu ekatambo. That is to say, well, if you want to translate it literally, it means European rule saved fools like you. Because if it wasn't for that, I would have killed you. But because I fear to be killed, because you know, actually these African languages are richer than even some of the foreign languages. Because in a very few phrases you can put a lot of meaning. So in that simple phrase, all these are contained, that first of all, European rule saved fools like you. If it was not for European rule, I would have killed you. But since I fear to be killed, when I kill you, then you are saved for today. That's what that simple sentence, Eshikirunga Katamba, means. It meant. That meant that the Munyankwere would have killed you if it was not for the fear that he would also be killed if he kills you. Now that means what? That means that the law then had a very strong deterrent effect. In the past, for example, embezzlers have risked imprisonment so that after they have been released, they can freely enjoy their ill-gotten gains. Incidentally, also another interesting thing among the Banyankore, among whom I grew, as far as the law is concerned, they used to say that if you kill a person, the Europeans would go get head of the deceased, make it talk, so that the head tells them exactly what happened, you see, so that you could not escape. They used to say that Nbagambisa omtogomfu, that is to say, they would make the head of the murdered man talk. And they believed there was a machine which could make the head of the dead man talk. But this was because of the effectiveness of the investigation machinery. Because the investigation machinery was effective, even though you tried to dodge, you would be found out. And to the ordinary people, that would be because the head of the dead man has been made to talk. And it has revealed all the details about what happened, and therefore you are prosecuted and convicted. So those two things, effective investigation and deterrent punishments, can preserve law in a society. The law must be reformed so that not only will they serve long periods of imprisonment, but must also on conviction be ordered to repay all the money they have embezzled. If they have consumed it, their property must immediately be sold to realize it. The same must apply to other crimes such as smuggling. A person convicted of smuggling must not only be made to serve a long period of imprisonment, but must also have his property confiscated by the state in equal proportion to the smuggled property he sorted out of the country. The sentence for misuse of office for personal gain is very light. It must be increased by sentencing the offender to a long period of imprisonment and by taking away his ill-gotten gain through selling his property. Yes, if you misuse government car, we calculate how much damage you cause the state, and we sell your property, and we recover our money. Not just lock you up and things like that. These are irrelevant because the state has lost. What does imprisoning you help or dismissing you? The money has been lost. The state wants its worth to be brought back. You caused it a loss. You must pay. This is my simple man's logic.
Most of you have been wondering why and how do people you have taken into police custody suddenly get out a few minutes later. That is called police bond. Then you demand that a person who was raped and that he went to the court and was granted his leave to get out. That is what Yoweri Museveni is saying 36 years ago. When we get back, you will see President Yoweri Museveni demanding for even more stringent measures against some of the suspects you are also complaining of right now. Don't go away. We shall get back.
Owanapaedia to me, Owanapaedia, Owana for history. If we go, Owanapaedia to me.
Banange, have you subscribed to Owanapaedia? I don't know what you are waiting for.
Owanapaedia to me, Owanapaedia, Owana for history.